friend of the court doubled dad's child support. That's really why we're here today.
Including issues of self-harm, snapping her wrists, telling
And
her
I'm going to
mother that
object
she
to
wants
that.
more
That is
time to
not
be with her
true.
father. Please stop cutting me off.
For the court, the defendant father's motion to modify parenting time and child support. This hearing is being conducted via Zoom. The parties have conferred this morning with Ms. Patrick, our Monroe County in front of the court. Please provide the court with the following recommendation that the defendant's motion regarding parenting time be denied for the reason that there is not a sufficient change of circumstances. The issue of child support, was that addressed this morning?
It was not, Your Honor. I did have a conversation with Mr. Sebastian about the past recommendation that the front of the court had done, but since we're not modifying the parenting time, we did not really discuss changing the child support.
Okay. I don't know if the incomes have changed or when support was last scheduled. Mr. Sebastian, is support still an issue if the court adopts this recommendation?
Your Honor, the only issue, as I understand it, if the court adopts the recommendation, is that the existing UCSO failed to account for a second family or defendant father, and that should have been accounted for, and the calculations would be affected thereby. Okay.
I suppose we can always refer the issue of child support to the front of the court for a formal investigation recommendation with an effective date of October 1st. Would that be acceptable?
Yes.
Right. Ms. Peterson-Ramsey?
Yeah, I would just, if he does have an additional family, which I understand that he does, and if that was not included, then of course I don't have any objection. That recommendation just came out in April of this year and no objections were filed. So I think he missed the objection timeline, and that's why we're here today. But obviously child support should be pursuant to the guidelines. And if he has a second family, we should look at that.
Again, I don't know when this child was born, if the child was born after that April modification or not.
Was not that his second family's been in existence. I don't know why he wasn't given credit for it. I wasn't part of that hearing.
Okay. Well, obviously that's Mr. Peacock's obligation to inform the front of the court of that situation. But in any event, with respect to parenting time, the court has read the pleadings and also the response, Mr. Sebastian, to your motion, indicating that, yes, even though there's a lot of people, mom's home, the boys have one room, the girls have one room, which is important to this court. Currently, dad's parenting time is week on, week off during the summer, but during the school year, it's just alternating weekends. Is that correct?
That's correct.
Was there also an issue about the school enrollment? The children are currently attend airport schools. And that are they currently enrolled in airport?
Yes, that's correct.
Okay, so they've not been changed. Dad lives in Wyandotte. All right, based upon the court reading the pleadings, Mr. Sebastian, the court's inclined to agree with Ms. Patrick that there does not appear to be a sufficient change in circumstances to modify parenting time at this time. Obviously, during the school year, we don't want to interrupt the activities of these 14 and 11-year-old children. Again, obviously, the allegations certainly raised the issue, but then the court reading the responses, that's sort of satisfied the court that there's not a sufficient basis to modify parenting time, even though there's cats. Obviously, the fleas do not seem to be a significant issue. There's the issue of missing school. That's a significant issue, but Ms. Peacock, mother, has addressed that and provided copies of doctor reports, and that's appropriate that if the children are missing school, they need to be seen by a doctor. That seems to address the issue of missing days of school. So answer, Mr. Sebastian, any else thing you want to add to your request this morning?
Yes, Your Honor. So subsequently to filing the motions, we received the notes from the minor child's therapist, and
I would just object to these notes because I have not been provided a copy of them. I don't even know if they exist. I don't know what he's looking at. So I would object to any reference to therapy notes that I haven't seen.
Mr. Sebastian, it's a good point. I mean, obviously, those should be forwarded to Ms. Peterson-Ramsey so she can appropriately respond.
Your Honor, she could obtain the notes. She actually goes to the therapist. She could have obtained the notes the same way my client did, and unfortunately, it took him a while to get these notes so that I didn't have them when I filed the motion. But there's a number of issues raised that I think go to proper cause in support of the motion, all of which mother is aware of that she's denied in her response.
Well, I guess if you want, we can, if you want to adjourn this for 30 days, you can provide a copy of those reports to Ms. Peterson Ramsey so she can appropriately respond.
Your Honor, I mean, I would object to any adjournment. I think the motion has to be denied. This is a threshold hearing and Dad hasn't met the threshold requirement. As far as the missing school, the grades have improved. The children have been in therapy. Dad's just not involved in the children's life to know what's going on. And he's made these baseless allegations with nothing to substantiate them. I would ask the court today for an order preventing Dad from discussing legal matters with these kids. Dad showed the children his receipt for attorney fees that he paid his attorney, and the children are very upset about knowing legal matters. So I would ask the court for an order today preventing either party from discussing legal matters with the children, showing them receipts that they've paid attorneys. The children shouldn't be involved in any legal matters. And I believe Dad hasn't met. Today was the date and time for him to meet his threshold. He hasn't done that. And I would ask that the motion be dismissed.
Well, the court agrees wholeheartedly with you. And Mr. Patrick, the court will add that neither party shall discuss these proceedings with the minor children. That applies to both parties, Mr. Peacock, Ms. Peacock. The children are minors. They should not discuss these proceedings any time with the children at all. So it's between the two of you and the court. So the court will add that to any order that neither party shall discuss these proceedings with the minor children or in their presence. All right, Mr. Sebastian, anything further? The court would agree. I mean, you apparently just received the reports. If in fact you believe there's a basis, you can file another motion. But based upon what the court has reviewed to date and the argument heard, the court is inclined to adopt this recommendation. So is there anything further then, Mr. Sebastian?
Well, I would ask the court suggested adjourning the hearing for 30 days. I think that would be wise as opposed to having to just refile the motion. I mean, many of the statements in the response to the motion made by mother were knowingly false because we have now the therapist reports. Mom is aware of the issues that the daughter is undergoing, including issues of self-harm, snapping her wrists, telling her mother that she wants more time to be with her father. Please stop cutting me off. So, Your Honor, there's a number of issues that mom is aware of because I know from the notes, the therapist is discussing it with mom. This may actually be mom's therapist. I think there's family therapy that's going on as well. So mom's aware of this. She could have had access to this notes easier than it took us. We were able to get the notes, and we weren't able to get the notes until after we filed the motion, or else we would have included a lot of this in the motion as well.
Mr. Sebastian, you could have easily emailed me any alleged therapy notes that you're telling the court that you have today. Today was the date and time for you to meet your threshold requirement, and you haven't met that today.
Which parent transports the children to their therapy? Are both children in therapy?
Yes, they are, and they have been for years. This isn't a change in circumstance. Dad is just not involved. Mom transports the children.
So does mom communicate then with the therapist? Is she aware of the concerns? And is she addressing those concerns?
Yes, she is. And we would deny that their concerns are evident, are there. And I think the grades reflect that. If these kids were self-harming, their grades wouldn't be as good as they are.
Judge, just in May, the school added extra appointments for the child, involved extra school personnel. And to say when she's failing drama and getting a D in fitness, that if she moves it to a C plus, that's an improvement, I suppose is true, but it's still clearly a problem on top
And
of
I would
all the
object to that.
absences.
Those grades are not accurate. She's gone in math. She's gone from a D plus to a C plus. In English, she's gone from a C minus to a B. In science, she's gone from a C plus to a B. And I'm not just going off what my client says. I've obtained the grades.
We have them
So
too.
okay, I don't know what middle of
She
the
got a
school
D in
marking
fitness.
periods.
Brother, so the central question is mom addressing the concerns of the therapists?
Absolutely she is. And she's been taking the kids to therapy for years. She's taking care of their mental health needs. Your Honor, the court should be aware that in April of this year, the friend of the court doubled dad's child support. That's really why we're here today. He didn't file objections to that child support recommendation. And that's why we're here today. And if you look at the procedural history of this case, every time the friend of the court has increased his child support, we're here on a motion. So the kids have obviously been doing fine all these years, but since the friend of the court doubled his child support, now they're not doing so good.
Your Honor, this goes to the fact that representation is totally false, and mom knows it, because on July 30th, the daughter told her mother with the therapist that she was unhappy at her mother's, that she wanted to spend more time with her father, that the mother's house was too crowded, there were too many pets, that was dirty, she was depressed, had poor concentration, decreased motivation.
Object to this. This is not true.
All of this was told to the mother per the
This is
note.
hearsay.
There was nothing to do with child support.
This is
a red herring argument.
The court agreed it's hearsay, but obviously Ms. Peacock needs to talk with that therapist and then address these concerns of the children. So if they're not being addressed, then yes, the court would take action. But at this point in time, with that direction to mother, the court will adopt the recommendation of Ms. Patrick with one addition, that the court will refer the issue of child support to the front of the court for an updated investigation recommendation due to the fact that Mr. Peacock now has another child involved. That may affect the amount of child support somewhat, but otherwise the court's going to deny the motion to modify parenting time at this time based upon the information the court has in front of it. If in fact, Mr. Sebastian, Mr. Peacock, if Ms. Peacock is not addressing these concerns or anybody as a therapist, by all means, bring it back before the court.
Okay.
Thank you, Your Honor.
Ms. Peacock will properly address these issues for the welfare, best interest of those children. Now, obviously, this keeping them healthy, getting them to school every day is critical, Ms. Peacock.
Yes, Your Honor.
The court had mentioned a commence date for the review. Could you repeat that commence date, please?
No, we're just, any modification of child support shall be effective October 1st. So
Thank you,
for the issue of child support, in front of the court, formal investigation recommendation, each side has 21 days which to object, and the commencement date would be October 1st of 2024.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Right, with that will conclude this matter. A copy of this order will be mailed to council. Now we'll conclude this matter, and we're going to zoom out. Have a good rest of the day.